Good morning. I'm pleased to welcome you to the 2014 Phoenix Center Telecoms Symposium Economists panel. The Economist panel is an annual tradition at the Phoenix Center, and it provides a forum for noted telecom policy economists to present an economic interpretation of current telecommunications policy issues in an accessible, insightful way, and I'm sure we won't be disappointed. We'll be both accessible and insightful again. Each of the panelists has selected their own topic, so I'm looking forward to hearing the topics as you. They do reflect their own point of view, and I should point out that the views expressed by the panelists are their own views, not necessarily those of the Phoenix Center or possible sponsors or staff of the panelist employer organizations. And in the case of Tim and I, as employees of the Federal Communications Commission, we would make the disclaimer that our views are indeed our own and not necessarily those of the commission or staff. Our distinguished panel this morning includes three well-known telecom policy analysts who work from an economic perspective. First, and this will be in the order of their presentation, is Dr. Dorothy Robin, presently an independent writer and consultant and former commissioner of the Public Building Service of the U.S. General Services Administration. Our second panelist is Dr. Timothy Brennan, presently Chief Economist at the Federal Communications Commission and concurrently Professor of Public Policy and Economics on leave from the University of Maryland at the Baltimore County campus, and I think, Tim, probably to which you will soon return. And finally, Dr. George Ford, who is and has been from the beginning the chief economist at the Phoenix Center. At the conclusion of all the presentations, the panelists will have the opportunity to ask each other questions about their presentations, and possibly we'll have time for a few questions from the audience.
I spent I joined the Obama administration, and having done some work on spectrum policy in my past, I was asked by the Obama administration to go to the Defense Department and oversee installations and environment. So all of the DoD bases worldwide and all of the related energy and environmental issues. And I spent 3 years there doing that, and it was a wonderful job. And among other things, toward the end of my time there, I became the spokesperson for trying to get a couple more BRAC rounds, base realignment and closure rounds, in order to get rid of excess infrastructure. And since no good deed goes unpunished, I was then recruited to go to GSA following a scandal there in the spring of 2012. And I succeeded a wonderful man who had been fired as the commissioner of the Public Building Service, and 3 of the regional commissioners had been fired. And I spent 18 months as overseeing the Public Building Service, the one of the 2 business lines of GSA, and the one that is the landlord to the federal government. It's actually a remarkable, in a very positive way, agency. But in the aftermath of the scandal, lots of issues, lots of bad press, a lot of jokes on late night shows, and I got beaten up a lot by Congress. That was nothing new. That also happened when I was at DoD. So when I emerged after 5 years, and Tom Hazlett reached out to me to talk about this proposal for creating a GSA for spectrum, and I was delighted to find that my old friends in the spectrum community were actually looking in a very positive way to some of the institutions and practices in the federal real property management world as a model. There was also a proposal to BRAC the spectrum. So, shortly thereafter, Brookings asked me if I would write about it, and so I wrote a rather lengthy paper, and I will just give you the sort of the bottom line on it today. First of all, there are a lot of parallels between spectrum and federal spectrum, all of the spectrum that is occupied by the federal government and federal real property. There are a lot of lessons, I think, to be learned from the way the federal government manages real property for spectrum. Challenges there, just as in spectrum, but I think there are lessons to be learned. But I don't think they are necessarily the lessons that people in the spectrum community have focused on. In other words, I think some of the proposals and some of the critiques of the proposals are coming from a place that is informed more by theory than by practice. So let me just say a little bit more about that. The major reason that people propose having a GSA for spectrum is that GSA, my old agency, Public Building Service, charges federal tenants, the Department of Justice, the Department of Transportation, rent for the space that they occupy in federal buildings, or whether it's government-owned or government-leased space. So they pay a rent that is equivalent to we call it a commercial equivalent rent, and we go to a lot of trouble to establish what that rent is, and in theory that leads agencies to economize on the space that they use, and there is a lot of feeling that we should be doing that in the spectrum world. This is actually an issue that divides economists within the spectrum world. A lot of them favor it, some of them don't. And I thought long and hard. I struggled with this issue, and I ultimately came down on the side of saying I think that charging federal agencies the equivalent of commercial rents fees, a opportunity cost fee for the spectrum that they use, is probably not a good idea because of the very, very high transactions costs. Charging agencies rent is conceptually fairly simple. The real estate market is very active. There is a database of comparables. It really should be, in theory, fairly straightforward to do that. In practice, however, what happens is that agencies fight over it. And a lot of federal agencies have created internal shadow GSA organizations which are designed to track and challenge what GSA does, and they are very quick to do that, and it becomes very contentious. And the courts, federal courts, are one of the primary litigants, and you wouldn't believe how contentious this can become. So huge debates, literally hearings and GAO reports devoted to how you measure vertical space, atrium space in a building. How do you measure that? Does that count as toward rentable square footage or not? I mean, that's just one example. So if you think about trying to apply that same approach in the spectrum world and measure what agencies should be charged for their use of spectrum, conceptually, I think it's a very powerful idea, but I think in practice it would be very difficult. So that's lesson number one. Now, I think the major reason for emulating GSA, the fact that they charge rents, is not the right lesson to draw. But I think there are others. And the second one, and this it came as something of a revelation when I realized this was not obvious to everybody, that in fact people in the spectrum community felt that people from, including Tom Hazlett on one end of the spectrum, Blair Levin on the other, that federal agencies are not motivated by the prospect of getting money or losing money. In fact, George's critique of spectrum fees is quite good, except that he dismisses them. One of the arguments he makes is that they won't incentivize the right sort of behavior on the part of federal agencies, because if they give up spectrum and therefore reduce their spectrum charge, it won't matter because the appropriators will simply keep the money. So they will not be any better off. And that's the general thinking, that with federal agencies, because they're not profit maximizers, they are not going to be motivated by the opportunity to either make money from selling or leasing spectrum, or they're not going to be motivated by charges that would normally incentivize more efficient behavior. That is absolutely, emphatically not the case in the real property world. And I think this is my major contribution in the Brookings paper, is to push back against this idea that federal agencies are not motivated by the prospect of making money from getting rid of excess assets. They absolutely are, if the incentive is structured properly. The ability to retain proceeds from the sale of excess property is an enormous motivator. And I say that based on 20 years of experience working with the military services on BRAC. They were, in fact, the way that the Office of the Secretary of Defense in the late 80s, my predecessor, got the military services interested in taking on additional BRAC rounds was with the promise that they would be able to keep the proceeds from those sales. And so Congress went along with that, and they created a BRAC fund, and the proceeds from the sale of property go into the BRAC fund. They don't require annual authorization. That's a big deal. They have standing authorization, so the services can appropriate them. So it's set up structurally the right way in terms of the budget. It's also important that it goes to the right level in the organization. And agencies are sensitive to the way that to where the money goes, and I have a number of examples of that. But trust me, there's there are differences between spectrum and property, but I believe this is a exportable lesson. I think if federal agencies could keep the proceeds from the sale or the lease, the long-term lease of property, that you would see a response. There is legislation, as you probably know, the Guthrie-Matsui bill, but it would only let agencies keep 1% of the proceeds. Now that, when you hear 1%, you know, okay, there's a CBO OMB scoring issue there, and there is, and that's a longer conversation about how you deal with that. But the ability to retain proceeds is a very powerful motivator. The budget process is very sticky, and agencies are broke and they're desperate, and they absolutely are motivated by the prospect of getting money from sale or long-term lease of excess property, I think, be it real property or spectrum. One last thing, there are a number of other authorities that allow GSA and DoD to do things other than just sell property that I think are also relevant, and I'll mention two. One is long-term outleasing. I know George doesn't like the idea of the federal government leasing as opposed to just selling, but there are occasions where you want to hang on to something, and I'll give you an example from GSA, and that's the old post office, where we did a 6-year outlease to the Trump organization. Trump organization was selected through a rigorous competition. It's a 60-year outlease. They pay us rent. They invest $200 million in upgrading the building, turning it into a luxury hotel. There are reasons that the federal government wants to hang on to that building, but a 60-year outlease is a good disposal approach. Second, the concept of exchange, barter. This is a very familiar concept in the real estate world. It goes back. It's part of the. It was part of Mayor Gray's deal to do the soccer stadium down at Buzzards Point. He was going to exchange a building on 14th Street that the incoming mayor has taken off the table. So it's an old concept. It's become more popular because it is a way to avoid some of the complexities of the budget process and the appropriations process. So here, I'll give one example, and then I'll close. There is because this example is so analogous to notions of federal hoarding of spectrum. There is a building in Kendall Square. Kendall Square is in Cambridge, Massachusetts, adjacent to MIT. Was very run down when I was there many, many years ago. It's now some of the most valuable real estate in the country. And the Department of Transportation has a huge building there. It was built as a NASA facility in the Kennedy administration. President Johnson moved the activity to Texas, and DOT took it over. It's called the Volpe Center. It sits on 14 acres of land in the heart of this unbelievably valuable Cambridge Square, 300 surface parking areas. It's an old rundown building. GSA is in the process. GSA has put out a notice to developers saying, give us your ideas. We want to upgrade this building, turn it into a beautiful state-of-the-art facility, and we are willing to exchange a large portion of this 14 acres in order to do it. And it could be barter. Give us your ideas on how to do that. And that is underway. I think there are a lot of opportunities to do that sort of thing in the spectrum world as well. I'll stop there.
Now for something completely different. I want to thank Jerry for the disclaimer. It's certainly valid and credible. One of the things I've said to Larry when he asked to do this, to say, I think these talks would be a lot more interesting if they were given by the former chief economist, not by the current chief economist, because I'd be, a little more able to talk about some things perhaps than I am. So see me in January. I just want to mention three things briefly. One about, it's sort of relevant to competition analysis fairly broadly, something I've learned in the last year. A second is on the organization of economics at the FCC. And a third thing is about a particular kind of non-economic argument that I'm actually kind of interested in. This is one where the disclaimer really, really does apply, I guarantee you. The first of these involves the role of bargaining theory. Let me tell you why I think that that's interesting, at least why it's interesting to me. I tend to be kind of, when approaching antitrust issues, being kind of a Chicago-type person, partly because I think it's kind of right, and partly because I think that there's some virtue in simplicity. And one of the tenets of that basically has been that sort of purely vertical arrangements are not a problem unless there's some reason why one side or the other can't capture whatever market power they have directly. This idea is not new. It was why Bill Baxter, quite a Chicago person, enthusiastically litigated the antitrust case against the old AT&T back in the 80s. So, leading to the divestiture. So it's not an unfamiliar notion, but it's something that at least I had sort of thought was kind of restricted to regulations which sets limits on whether a firm can exploit market power directly. But it turns out there may be some other limits, and in particular, if prices are set by bargains between buyers and sellers rather than on a kind of take it or leave it basis, then a buyer or seller with perhaps market power, or at least ability to set power to set price over their marginal cost, may not be able to capture all of whatever profits that they might be able to extract, because the nature of bargaining is you have to share them with somebody in some way, shape, or form. Now, I'm not sure empirically throughout the economy how important it is to worry about bargaining. An example I've used in thinking about this is that people haggle over the prices of cars when they buy them, but I'm not sure there's anything really, really fundamentally interesting about the car market that has to incorporate the fact that that people haggle over a few $100s, when they make the purchase. But at the FCC, bargaining matters a lot because for reasons kind of peculiar to the sectors that it deals with, there's almost always a lot of money at the table in a transaction. Things are not driven down to a point where price just equals cost, so the marginal profits are pretty small. You've got on the one hand, say, program suppliers, where once they produce the program, at least in the short run, the cost of distributing the program are essentially zero. And on the other hand, you've got buyers often in markets that at least arguably aren't so competitive that they're driving their own prices they're willing to pay, kind of like up to the level of the value of the property, of the programming, say. So there's always some rent around. So bargaining matters. And where bargaining matters, that can have the same sort of effect as a regulatory price ceiling. And it may be that vertical integration facilitates some kind of ways of extracting market power that you might otherwise get. Now, I think it's a mistake to sort of leap from the possibility to the conclusion that vertical integration is always bad. I think that it's kind of, one's got to be careful about it, but it sort of opened my mind to something I wouldn't have thought of before. So that's the first point I wanted to mention. The second point's on organization. Other chief economists might want to portray this a little more favorably, but in fact, the chief economist at the FCC is very much like a visiting academic. It's not like the antitrust division of the Federal Trade Commission where there is a bureau or some sort of group of economists that reports to the chief economist. Basically, I sit in a windowless office. They found a broom closet for me. They put me in there, and nobody reports to me. And unless somebody calls me, I don't really report to anybody else. Unfortunately, I know some people there, so I get called. But anyhow, I kind of knew a lot of that going in. And I knew that there wasn't, say, an economics bureau at the FCC. What I didn't know going in, which really genuinely surprised me, is that within the bureaus in the FCC, the Media Bureau, Wireless, Wireline, International, which employ quite a few economists, each of those bureaus, that the economists in those bureaus do not report to an economist. And my first job out of grad school was at the antitrust division, not long after George Hayes and Don Baker essentially created a separate office of economists in order to preserve independence, promote disciplinary identity, contributing, doing research, that kind of stuff. Particularly on the independent side, that's really important. So I'm a big believer in that sort of thing. And if there was one thing that I could change about the FCC organizationally, it would be that. Now, the third point, and again, let me reiterate here, this is where the disclaimer really applies. I can't talk about them in detail, certainly, but it's no surprise to anybody in this room, kind of like Larry talked about the theme of the conference, that this last year at the FCC has been an interesting time in Confucian terms, and one of the things that sort of strikes me about, when I think about a lot of these controversial issues, it seems that they're partly controversial for a reason is that they're hard. And so one of the things that always strikes me about it is how people can know the answer so quickly. Now, on the one hand, if you have like these ideological commitments, about whatever, then that's kind of explicable. But that's not always the obvious answer. And I think there's one thing to think about. Let me think about the following idea. And again, this is purely me. Jerry may tackle me after I say this, which is one of the things that economic analysis rests upon is the assumption that firms are profit maximizers. And one of the things about profit maximization is that if a firm is maximizing its profits, in a lot of respects, they are on the same side as consumers. You know, the more consumer surplus they can create, the more that they can extract. And this part gets back to what I was saying before about vertical integration being somewhat benign, is because, well, gee, people can already do that. It doesn't really change incentives at the margin. You know, sure, they'll charge a lot for that, they'll extract that, but if consumers want higher quality, they'll provide higher quality. If consumers want a different spectrum of services, they'll provide a different spectrum of services. Now, what that means in a policy discussion goes something like this, is that on a lot of things that people are arguing about, like discrimination or something like that, the profit maximization assumption could would lead me to say, you don't have to worry about that. They'd lose money if they did that. That doesn't provide a lot of people with a great assurance. You know, and which leads to the question is what people are worried about not whether they'd maximize profits, but whether they would use their position in one way, shape, or form to do things that may not be profit maximizing, but might have other things in mind. It might be arbitrary, it might be ideological, whatever it might be. And I just sort of wonder whether that's the thing people are worried about, and that's what allows people to reach very, very quick decisions about matters that seem to me to be quite complicated if you assume, especially if you assume firms are profit maximizers. I'll just leave it at that and turn it over to George. Thanks very much.
Thanks, Tim. Dorothy, too. It's fun when you write a paper on a topic and then a trained economist who actually worked in the organization doing what you were commenting on writes a paper on it. I think I stood my ground pretty good. I think we could have a few arguments, but many of the points she made were qualifications and caveats in my paper, so that would be a good conversation, and I generally agree with her thoughts on that. I'm going to talk about the tariffing the internet paper mainly because that has been an issue of contention and disagreement, and we sort of stood alone on this issue. It was one of those things like the paper we did on the government spectrum, where you kind of stick your neck out there. You're not quite sure. Sometimes you're absolutely correct about something. I don't like to do that very often, but you do have to on occasion. And this was one of those issues because I kind of came up with it on my own to some extent, although I think others were thinking it already. And as an economist practicing law, that's a very dangerous prospect. But fortunately, I work with a lawyer and have lots of lawyer friends. I think to start with, I wanted to make one point because it's every now and then you get those thoughts that one of your old professors tells you, and you keep coming back to it. It's like the Sutton model of industry structure. Is the ideas versus policy, and I used to call. I don't do it anymore because he beat me up so badly on it. I used to call my former professor and colleague Randy Beard, and I discussed this thing, and he goes, "Well, George, that's not a policy, that's an idea." And what we're talking about, for example, open internet. The open internet is an idea. A policy is you'll clean the bathrooms at 8 a.m., 12 a.m., 4 p.m., and 8 p.m. That's a policy. Right? When you interview people, you will invite 3 people to campus. That's a policy. Okay? Hiring good people is an idea, or keeping things clean is an idea. The open internet is an idea. It is not a policy. It is not a set of rules. And Tim had some ideas about improving the FCC. My improvement to the FCC would be when you come in, you have to have attached to your comments a specific set of rules that you would like the FCC to implement. You don't get to come in and say, I want an open internet, because everybody has a different opinion about what that is. And if you watch the policy debate, you'll see this all the time. All the time. Okay, they're ideas. They're not policies, and you have to get down to the policy because that's where you run into problems. That's how this paper started. What would reclassification look like? What if you did make broadband a Title II product? How would it play out? Specifically, how would it play out? And because that, I mean, just think, okay, we declare broadband to be Title II. Now what? I mean, right? That's the question is now what? Does that just solve all the world's problems and everything is perfect and we can leave Chairman Wheeler alone at his house and let him back his car out without trouble? Does that solve the world's problems? I mean, it doesn't do anything. Okay, it's just like step one. So how does it work? Well, regulation is about relationships. Okay, the regulator is getting involved in the bargain between two entities, usually consumers, companies, whatever it may be. So the first thing you got to ask yourself is what transaction is going to be regulated. Then you got to ask yourself what problem are we trying to solve? Okay, or you might actually say what's the problem, and the people might pop out of that, who's involved in that, either way. And then what tools do you have to solve that problem? Okay. What is the transaction of interest? And this is the biggest issue. It's not anymore. It's been cleared up. But it was contentious for a while. And I think that oddly enough, there were some other people, and I will point to them later, that pointed this out clearly, but this was not where the debate was going on network neutrality or the open internet. If you look at the 2010 order, okay, who are the parties? If you're going to regulate something, we regulate the price of firms charge consumers, right? You got consumers, you got firms, and that's where we're regulating. Sometimes we regulate interconnection between CLECs and ILECs or whoever it may be. Okay, so we're regulating these relationships. Who are the participants in the transaction of interest? That's the first question we want to ask. The 2010 order has three problems. It lists three problems with respect to network neutrality. These are the three ugly incentives that we're trying to fix. You'll notice the first, broadband providers may have incentives to block or otherwise disadvantage edge providers. Okay, I'm not going to read it all because we're short of time, but I've highlighted words. Okay, they are broadband providers and edge providers. Price and quality of access to end users. Okay, broadband providers, edge providers. The second incentive, broadband providers may have an incentive to do something to edge providers. The third one, broadband providers may have an incentive to do something to edge providers. Okay? In all cases, if there's some incentive that's problematic, that warrants this regulation, it's always the broadband providers in some sort of relationship with the edge providers, not the consumer. The FCC's 2014 NPRM states explicitly that what we are interested in is the second side of the market, two-sided market idea between broadband providers and edge providers. Okay? And we can go on and on and on. DC Circuit, broadband providers could be carriers to edge providers. Broadband, this is Mozilla's petition. Here's someone else that was thinking along the same lines. Broadband providers and edge providers, in addition to its duties of interconnection. So this is entirely separate from carriers interconnecting with each other. This is a relationship between a broadband provider and Netflix, not broadband provider and Cogent or Level 3 or Comcast and Verizon. It's between Comcast, Verizon, AT&T, whoever it is, and Netflix. And this is a relationship that has not existed formally yet. Okay. But now with network neutrality, we are making this a formal relationship and we are going to regulate it. Okay. So then this is the market we're talking about. Okay. The consumer's got nothing to do with this. And there was a huge argument about it, okay? Public knowledge, free press, saying I was nuts for arguing this. Of course, then the chairman comes out with this hybrid approach, which is what? We're going to leave retail as a Title I service, and we're going to put network neutrality on the termination side of the market. That's exactly what he proposed. I said this before he said that, by the way. What problem are we trying to solve? Let's go back to our three incentive problems. Number one, price. Number two, charging edge providers. What are you charging? A price. Number three, charge edge. What is this? Price. And you may say quality with throttling and things like that. But it's price. Okay? So we got a termination market. And what's the problem? We don't like the price that the broadband providers are charging the edge providers. So what do we got to do? Regulate price. Okay? So what kind of regulator are we talking about? Price regulation. Even the DC Circuit recognizes this. Even. Regulated price of 0. Okay? We'll come back to that. What's the problem? And this is what bugged me about it, because everybody says it's not, people tried to argue it's not price regulation. What is, if you were to summarize network neutrality to somebody, you'd probably use paid prioritization. Paid prioritization. It's price. By definition, we're talking about price regulation. So, 2 other issues. We have to regulate them, of course, because they're monopolist. We don't regulate competitive markets. The FCC has declared all broadband providers to be a market unto themselves. Okay, the geographic market of Comcast is Comcast. Okay, so it will always be a monopolist by definition, according to the FCC's logic, which I think is deeply flawed. But let's go with what they're arguing for a moment, since they get to make the decisions and I don't. A couple of terminating monopoly stories here from the FCC orders. So what we have, network neutrality is, in my mind, without question, price regulation in the termination market. And I think it's pretty clear, the hybrid proposal, that the chairman thinks the same thing. Now, I don't know how he feels about price regulation, but a 0 price is price regulation. How are prices regulated under Title II? Anybody here know anything about Title II regulation? It's tariffs, man. You file tariffs. That's what you do. And it's not, you may file a tariff. You are required to file a tariff. In fact, when the FCC told the long distance industry, you don't have to do that anymore, the court says you can't tell them that they don't have to do that anymore. You don't have the right to stop them from filing tariffs. That's another issue why they wanted to, but they wanted to. And there are many other cases and statutes, and copyright issues, an issue I was involved in. The copyright royalty judge just says, well, I'm not going to set that price because I don't have any evidence on it. And the court said, oh, yes, you will, because you are required to by statute. Okay? So you got to do it. But of course, there's some issues with that. Okay? 203 tariffs are required to make sure that you comply with 201 and 202. The government says. The company files a tariff. The government doesn't say come file a tariff. The company files a tariff, whatever they want to sell, and the government looks at it and says yay or nay. And if they say nay, you have a big fight. Sometimes. But the rates can't be arbitrary, and they can't be confiscatory. Ages and ages and ages of history on regulatory history on this. Can't be confiscatory. That's pretty important when you're talking about regulating to a price of 0. Because I can assure you that a 0 price is, in almost all circumstances, confiscatory. Unless you're regulating something else simultaneously in which you can argue that, well, they get that over here, so we're going to, but you got to regulate that to make sure there's balance. Also, the definition of a common carrier service is for a fee. Okay? So if you make it a common carrier service, it got to be for a fee. That's the definition. Title II prohibits 0 price regulation, I think, generally. Okay? You may end up with a case, for example, interconnection, some interconnection, bill and keep. But that comes in a specific, very specific world where I got a ton of traffic and you got a ton of traffic and we're making a trade. And really, it's not that the price is 0. It's just that if it's in balance, it ain't worth billing each other for it. I think when it gets grossly out of balance, then it doesn't make sense anymore, even though the court said it did. I think that decision will eventually go down when you find a really good example of highly imbalanced traffic. It's just a dumb decision, but courts make those quite often. But they do solve the problem eventually. Title II also permits paid prioritization. Generally, we do this all. Special access is paid prioritization. That's what it is. It's special. And we do that all the time. Okay? So it'd be very difficult to say no. If I come in and say I offer a better service at a higher price, because it's not that the FCC says you can do it. It's that the company comes in and says, here, I want to offer this higher quality service at a higher price. And the FCC has to review the tariff and say yes or no. If it says no, you can't, then you probably get a good case against the commission on that. Okay? Or if the commission, and this is the craziest argument I've ever heard, and the chairman has made it, that you should offer a higher quality service at the same price. Well, that's discrimination, explicitly. Okay? That'd be a violation of 202, although I'm sure we've done it in the past. Why not just forbear, right? We're going for the Title II light. We're going to declare it a Title II service and then just abandon everything. Some people even argue we're going to abandon 201 and 202 just so we can get the common carrier moniker and then regulate under 706. This is insanity. Of course, common carrier service is still for a fee, so you're still stuck with that. But why wouldn't you forbear from tariffing? Why is it that you would? What does that get you? I mean, isn't the point of network neutrality regulation to regulate the price? To regulate the terms of the deal? If you don't regulate the terms of the deal, what happens? They do whatever they want. That's what they do in wireless, right? You walk into a wireless store, you get a deal, I walk in, 5 minutes later, I get a different deal. You can discriminate all day, you can do whatever you want, okay? If you don't tariff it, and you can look at the Orloff case to see this, if you don't tariff it, then the companies get to do what they want to. So the mere idea that you would forbear from tariffing is silly. How are you going to set a price? How are you going to control paid prioritization if you're not controlling price? Look at the Orloff case. But anyway, I'll be done because I know I'm over time. This is a story. You can read it in the paper. We got blogs. We've got op-eds if you want to read the whole paper. And you've got a pretty good feel for it here. But this is how it goes. And I would really characterize this as what the box that the commission finds itself in. Do I expect that the FCC is going to write an order that says file tariffs? I don't. I think they're going to have a real problem, particularly rate of return carriers. That's a different game that many of you may not know about, but this would be hard to argue that they don't get to file a tariff on that. But I don't think that's what they're going to do. But this is the box that they are trying to claw themselves out of. This is why there is no open internet order yet. This is why it's not easy peasy. Because the FCC is stuck in this box. It can't forbear from tariffing because it would be stupid to do so. And even if it tried to forbear, you're forbearing in the presence of monopoly. The FCC doesn't do that. Okay? And while they say, oh, well, the wireless is always a terminating monopoly and we forbore wireless before, we forbore in the retail segment. Okay? We focused on competition in the retail, and this termination thing was just this side thing we'd keep an eye on. The network neutrality is solely about termination. That's the only thing it's about, and the FCC has declared that market to be a monopoly. So this is the box it's in, and this is why they're trying to figure it out. It's hard, very hard. I challenge any of you to come up with a good economic argument or even a good legal argument under Title II that would permit a no-blocking rule, that would permit zero price regulation. It is very, very difficult. And certainly the paid prioritization, I think, is a very, very complicated and difficult argument. That's my story. Thank you.
I want to thank all the panelists for appearing this morning. Tim, thank you for your service to the commission. I will just exercise an editorial prerogative. Tim has really worked very hard for the Economist at the commission. That's thankless labor, much appreciated. He's also a great guitar player. Plays in the FCC band. He's terrific. We're going to miss him. Thank you all, and we're ready for the next panel.